Welcome to CAM Radio, an Ahead of the Curve initiative by Cyril Amarchand Mangaldas, bringing you every Friday the latest in legal and policy. Stay tuned. Enjoy listening.
Now may I invite Honourable Mr. Justice UU Lalit, former Chief Justice of India, and I would like to say distinguished professor at Jindal Global Law School to say a few words.
Namaste and aloha to all my friends from Hawaii. Good morning, everyone. It's an absolute privilege to be here before this gathering. I did about 40 years plus in the field of law. Was 32 years as a lawyer, then 8 years plus as a judge. But I never had the opportunity of being here in a firm of solicitors and in front of a gathering like this. It's a great opportunity to be here. Well, today we shall be discussing various topics which are engaging the attention of the legal fraternity, the community all over the world. But just to give a glimpse to all these jurists and judges who have come from America, Marbury versus Madison has been one of the greatest milestones in the history of judiciary all over the world. We here, as Indian judiciary, we have gone way beyond Marbury versus Madison. Our concept of judicial review doesn't stop at striking down executive actions. It goes well beyond that. Not even just striking down statute law, but our Indian Supreme Court has struck down even constitutional amendments. So therefore, that's the level to which the judicial review issue has been taken by the Indian Supreme Court. We are a young nation, just about 75 years old. Our judiciary is still in those nascent stages, but a robust judiciary, which is emerging, which is willing to take challenges as the times may offer, and which has stood the test of time. After Marbury versus Madison, the greatest, perhaps I think the pinnacle would be that we struck down something which was a constitutional amendment dealing with the appointment of judges. We are perhaps the only country where the judges appoint their own successors. The executive has a very, very less role in selecting the judges. Why? Because we believe in independence of judiciary to such levels that we don't want even executive interference in selecting the judges. So that's the level to which the concepts have been actually taken, have matured, and have been part of our juristic ideas and jurisprudence. That's the cost to which we have taken. We have, in a pursuit for excellence, we have borrowed some of the concepts. We have learned from those ideas. As Justice Krishna Iyer once said, and if I may quote his expression, he said, not the Potomac, but it is the river Thames which irrigates the flow of interpretation in river Yamuna. That is what why he wanted to say is that not the American ideas, but we are closer to the English jurisprudence when it comes to interpretation and other ideas. It is true that we have borrowed the system from our British rulers. The basic idea is English jurisprudence, but we have developed far beyond that. Like, for instance, Justice Bhagwati quoted Justice Frankfurter in one of his celebrated judgments to say that the government must be held bound to the policies it professes. So therefore, that's what the ideas have germinated in our thoughts. We are taking everything way beyond, and today the judicial approach has been that it's quite innovative. One instance which I may give you, and Mr. Cyril Schroff mentioned about Article 21 and right to privacy being included in Article 21. We are a young nation. When we got independence, 60% of our population was illiterate. Today, that literacy has been the flame. The literacy has actually reached everywhere. We are a young nation. Majority of our population is well below 30 years of age. So what has happened is, it is the judicial court which read right to education to be part of right to life. And well before the constitutional amendment sought to make right to education a fundamental right, it was the judicial approach, the judicial interpretation which said that if you want to have a meaningful life, that meaningful life cannot be achieved or attained without the source of education. And that is precisely why the celebrated judgments of the Supreme Court said that right to life must include right to education. So that's one example where the judiciary has been showing the path to the nation. The judiciary has been quite innovative in ideas. It is after judicial decisions that the parliament stepped in and made right to education a fundamental right. So who was the initiator of the idea? It was the judicial approach. So therefore, our judiciary, Indian judiciary, is not just stopping at the level of interpretation and saying what the law is. At times, it goes to the extent of saying what the law should be. That's what the approach of Indian judiciary has been. So welcome to our country and welcome to these discourses and discussions. We are looking forward to meaningful discussion where we as persons who are proud of our heritage will be learning from your experiences. Welcome. Thank you so much.
Should also
Thank you so much,
mention
sir.
that Justice Lalit was one of the few who was directly elevated to the Supreme Court, and that's a measure of his erudition and his contribution to the law. I should have mentioned that in the introduction. So we are again proud of having you here, sir, today.
Thank you.
May I now invite Honourable Mr. Justice Swatanter Kumar, former Judge, Supreme Court of India, and former Chairperson, National Green Tribunal, to say a few words.
And also Chief of the Bombay High Court.
Good morning to all of you, and special welcome to our foreign delegates here, my elder brother Justice Sri Krishna, and my younger brother, but the former Chief Justice of India, Justice Lalit, and the distinguished Sharaff family. Both of you are not only elegant, but you are marvelous in your work. Not only your work is shown in your day-to-day professional activities, but the very structure here shows that what are your interests beyond making money. Thank you for accommodating all of us. See, rule of law is a subject which has been very controversial, not only in our country, but across the globe. In our country, Article 14 provides for equality before law and equal protection of law. The purpose of the judiciary is primarily to interpret the law. And while interpreting the law, more often than not, the Indian Supreme Court has been criticized for so-called judicial activism. In my humble opinion, judicial activism is neither fundamentally wrong nor objectively wrong. It is to be understood in the concept of judicial creativity. A judge must advance itself as per the need of the society. The law originates itself from social norms of a society. Therefore, the judges should be given their due for expanding the law by way of creativity. All the judgment that Justice Lalit referred to, and not only this, I will be talking a little about on environment. Article 21 was expanded by the Supreme Court to say that the right to decent and clean environment was a fundamental. And with subject to correction, India is the only country which places the right to environment at the constitutional level as a fundamental right and not a constitutional right. The distinction between the two is very fine, but its remedies, scope is entirely different. So we have expanded Article 21, the Supreme Court of India, to expand all the basic rights like education, right to life, right to clean and decent environment. Everything has been done, though the Article 21, if you would kindly know, it's just one line article. But the scope which has been expanded by the judiciary is for the humanity and good of the people of our country. What I would say is that Indian judiciary has been there not for a very long time in comparative terms to the developed country. But if we see it, the judiciary in India is not controlled by anybody. Unlike UK, unlike your states, where Senate is dominant, their statutory principles are controlling the jurisdiction. Here, the Constitution and the Supreme Court said that you can't touch the basic structure theory of the Constitution, which was not an easy judgment to give, with the governments being quite strong in India, being a democratic country. Therefore, the judiciary has been, and the rule of law clearly says that you should have easy, inexpensive, and expeditious justice system in a country. And we are today, every taluka of our country has a court. That means the common man, even from the most deserted part of the country, can have access to justice. And there are a lot of firms, and I'm very happy so that they are doing so-called corporate social responsibility. They are making people to come, make it easy for them to come to the courts. One of the most common things we have just said, whether Michael said it or all of you mentioned about, is that there is a clear distinction between US and India in its certain systems. But what I find most common between us is that our hearts are alike. People from US, Hawaii, when you go to them, they are so kind, they are so hospitable. And when you come to India, I'm sure by the end of the day, besides being thoroughly tired, you will be very happy to know that everybody would welcome you with their open arms. And that is the Indian culture we have. While again welcoming all of you, I wish you have a very enjoyable time in India, in various parts where you're going. And Raj, as was said yesterday on the dinner, that he is a tough man, not only to look at, but even otherwise. And it's going to make you work. And one thing I would certainly like to mention with his lot of work into the education field, and that day is not far when people from across the world will like to come to Jindal and do their studies in Jindal because he's developing it so well. So, Raj, it's really a good work. Thank you, all of you. I wish you all the best.
Thank you very much, sir, for those very thoughtful comments. As was mentioned earlier, Justice Swatanter Kumar influenced and inspired the development of the environmental tribunal and court system in Hawaii, and that has also become a movement within the United States. So thank you, sir.